Sorry.
Morning. Nakia Smith.
You're on main jail.
Oh, crap, I gotta text files.
Nakia Smith. Morning, man. You're touched.
Good morning, Judge.
Good morning. We'll work from there.
Theft, 2008 Tampa.
All right, ma'am. I'm setting your bond in the amount of $3,500.
Judge,
Contact
if
with
the
the victim,
defense,
direct or indirect.
Judge Hector Romero with the Public Defender's Office, if we can be heard regarding Ms. Smith's ties.
Certainly.
Judge, in speaking with Ms. Smith, she's been residing in South Florida her whole life. She is 42 years old. She's currently employed. She works at Publix. She's been working there for the past 3 years as a clerk, making $14 an hour. Unfortunately, financially, her resources are very limited. She has no money in the bank, no property. She's a mother of 4 children, ages 24, 9, and 6, and 4. Your Honor, she's the financial provider for these children, especially the younger ones, 9, 6, and 4. She does have a separate place to reside other than with the alleged victim. If you do order no contact, we'd be asking you to set a reasonable bond and take into account Ms. Smith's financial resources. We'd be asking for $1,500 bond.
Your Honor, based on the prior domestic violence arrest, even though there was dropped, I believe the $3,500 bond's appropriate.
Your Honor, local victim advocate from the state attorney's office. I did have contact with the listed victim. He indicated he is not in fear. He wants the defendant released and he wants contact.
Under the circumstances, I will set the bond at $1,500. No contact with the victim, direct or indirect, until further order of the court.
But Judge,
Yeah.
are you imposing the no contact order considering the victim advocate said the victim's not in fear?
Yeah. At this point, I'm imposing that, but I'm reducing the bond to $1,500.
Thank you. One other thing, because they have children in common, the 3 kids, Your Honor, for purposes of arranging child care, can they do it through a third person?
Yes.
Thank you very much, Judge.
Khadijah Roberts.
Ms. Roberts is coming up, Judge. Come on up, please.
Ms. Roberts, you're charged with touch or strike, battery, domestic violence. I do find probable cause.
No criminal history, Judge.
Judge, in speaking with Ms. Roberts, she's been residing in South Florida her whole life. She is 22 years old. She is currently employed. She works at Humana. She's recently obtained this employment. She's been working for them for the past 6 months, making $12.50 an hour. She has no money in the bank, no property. Judge, she does have a 1-year-old child. As the state confirmed, this is her first arrest. We'd be asking you to consider an ROR on Ms. Roberts' behalf.
All right, I'll ROR to pretrial release. Correct. No problem.
Judge, could you sign a photo order allowing us to photograph Ms. Roberts?
She's getting released, Hector.
Oh, she's getting released? Oh, okay, thank you.
I'm
Thank you.
RORing the pretrial, but if you need her picture,
No,
taken before she gets
I'll
released,
advise her
that's
to do
fine.
it on her own.
Okay, that's fine.
Thank you.
Leonard Platt.
Mr. Platt, come on up.
Platt, you're charged with violation of probation, a misdemeanor based on the warrant. I do find probable cause. Currently being held no bond. Injunction. Good luck to you, sir.
Yeah, straight that way. Thank you, sir.
Rory Alejandro Suarez,
Judge, I believe that's
Judge,
a
I've been advised Mr.
medical
Suarez is a
reset.
medical loan.
medical reset.
It's not here. I think it's a photocopy down here because the original's already passed along.
Delvin Prince.
Judge, Mr. Prince is coming up. He advised me that he has private counsel, Mr. Julian Stroman.
Okay. Mr. Prince, you're charged with battery by strangulation. I do find probable cause state. Does he have priors?
Your Honor, I'm showing an arrest in 2015 in Dade County for battery. That was dropped. I'm also showing out of the state of Virginia, 2010, an arrest on charges of maiming, abduction, and preventing phone communication. All charges were dropped.
Offense? All right. Prince, I'm setting your bond in the amount of $5,000. No contact with the victim or direct or indirect. Michelle Clark.
Judge, she's over at the North Broward Jail. I did have an opportunity to speak with her. She's represented by Regina Tomanakis. I sent her a text message. She's currently in court. She'll be on her way here.
Okay, I'll put that on recall then.
Thank you, Judge.
Sasha Sherifant.
Judge, she's represented by Johnny Weeks. He came to court today.
Oh, I
He's
saw him here. I think he just stepped out. I'll put that on
I think
recall.
we have 17.
Okay. Is Sasha Sherifant?
John Weeks on her behalf, Judge. Good morning.
Good morning.
I'm going to do that. I was going to wait till after the GBs, but I'll
Do
do
you know
that.
if she's in the main jail?
She's at
North Broward. Okay. North Broward, can you hear me? Hello.
Who are you looking for, Your Honor?
Sasha Sherifant. Sharon Font.
Sheriff.
Cherdenfant.
I think that might be enough.
First, I just saw your computer. I'm like, yeah, I've seen that before.
She's a medical reset, Your Honor.
And Mr. Weeks, what would you like?
Judge, I think there's some issues with the PC in reference to how they got in the vehicle. That being said, I'd ask the court to lower the bond. Her family's here. She's got $250,000 bond on, or that was previously set on counts 1, 2, and 3. I'm asking the court. She has no history, from what I believe, unless I'm incorrect over there. And I'm asking the court to give her a $25,000 bond with standard pretrial. I think that's appropriate.
Date any priors?
It looks to me like she called the cops herself because she was going through a medical problem. When the cops got to the residence, they saw cocaine. And I don't, and from the PC, I don't see how they get from the house to inside her car, even with Judge Siegel's search warrant. It's like a huge jump. That being said, it looks to me like all the major drugs were found in a car, and it doesn't even indicate whether or not there's a car on it. I think the house is used by over 9 individuals at that house. So
Well, okay, first, because I don't know, does Mr. Weeks have an objection to PC, or is he?
Well,
is he?
I find probable cause.
Okay.
The question is
Yes.
Is bond amount, and does she have priors?
Your Honor, I'm not seeing any priors. If I could just have one moment. I would note, even with no prior record, Your Honor, but I would ask the court to take into consideration when setting, if the court's inclined to modify, if convicted of count 1, she faces a 15-year minimum mandatory sentence.
She's not there.
On one moment. On count 2, it would be
it's the same.
15-year, and I believe the same on count 3. So
They're all 15-year minimum mandatory, Judge.
Mr. Weeks, are you waiving her presence?
I am, Judge.
Okay. All right. After considering the fact that she has no prior history, I will reduce the bond. I'll reduce the bond to $25,000 apiece on counts 1, 2, and 3, $100 in count 4, for a total of $75,100.
Judge, I don't think the family could afford, I was asking all in one. Is there any way we can ROR one of them, Judge, and maybe make it 50?
I'll leave that to the division prosecutor and judge, but right now it'll be $75,000.
Understood, Judge. Thank you very much.
Thank you.
And Your Honor, if possible, another case, if we could call out a turn. There's a couple of detectives present in the courtroom.
Sure.
Darian Williams on
Page 15.
What page?
Date of birth?
Actually, you rocking his sweater today.
Darian Williams.
Darian Williams? Oh. Darian Williams, come on up, please. He's coming up. He's on page 15 of the docket.
All right, Mr. Williams, you are charged with possession of burglary tools with intent to use them, burglary of an unoccupied conveyance while unarmed, grand theft, and grand theft auto, and 2 out-of-county holds on misdemeanors. State?
Well, Your Honor, first I'd like to bring to the court's attention, looking at counts 5 and 6. Count 6 originally was a burglary that was pled out to a trespass. Can we go sidebar for just one moment? You can call after, but it doesn't mention it on count 5. Oh, I'm sorry, I didn't see it. We can go back on, Your Honor, I'm sorry. As you can see, there's a loitering and prowling attached to count 5, and I think that's relevant considering the allegations in this matter. Your Honor, we have a couple of detectives here. I think they have some information to provide to the court, some concerns they have.
Okay.
Not,
Is this going to be sworn testimony?
I think it has to be.
Okay, I agree.
Raise right hand. Please solemnly swear to affirm that you will support the truth and the
Could you state your name, spell your last name for the record?
Detective Duran.
All right, Detective, what did you want to...
We'd just like to add that we believe that Mr. Williams is a part of a more organized group coming out of Palm Beach County, which is this group crosses the border into Broward County to commit their burglaries. On the night that Mr. Williams was arrested...
Judge, I'm going to object to speculation in regards to being part of a broader group without any evidence as to such.
On the night that he was arrested, we're up to 21 burglaries. We're still sorting through various property at the development which committed these burglaries in the city of Coconut Creek. Also, Pembroke Pines. Unknown amount of burglaries. We're still going through the property.
Objection to the unknown burglaries too, Judge.
Hey, guys. Yo.
State you haven't record.
I
I do find probable cause
okay.
on all 6 counts. Just start with
Yeah,
that.
Your Honor. One, I'm gonna be asking for a $25,000 bond, pretrial release of the GPS monitor. My concern, one, is his future appearance in court. As you can see, he's got pickup orders on 2 separate cases that he absconded, failed to appear in court. 2, the concern, also, if convicted, and I know it shows us this, it would be a second-degree felony in count 2 with the enhancement for traveling across county lines. So I do have a concern for the property and the community.
All right.
Judge,
Yeah.
and speaking with Mr. Williams, if you could take into account also in determining his bond, as far as his ties, he's been residing in Florida his whole life. He is 18 years old. Financially, he's not working right now. He has no money in the bank, no property. He lives with his mother. They've been residing in the same location for the past 2 years. I know his intent is to enroll and get his GED, Your Honor. But unfortunately, once again, he's been residing in Florida his whole life, and he has no sort of financial resources. We'd ask you to set a reasonable bond and take into account Mr. Williams' ties and financial resources, Judge.
And Your Honor, I apologize. Can I ask the detective one additional question? It has to do with ties. Detective, at any point did you question Mr. Williams with regards to where he resides?
Yes.
Please tell the court.
Mr. Williams stated that he did not have an address and he lived in the streets. He would not provide us with an address.
All right, well, counsel, with all due respect, if he was going to get his GED, he probably should have done it in between these arrests. Accordingly, on count 1, possession of burglary tools, I will give him a $1,000 bond. Count 2, burglary conveyance across county lines will be a $5,000 bond. Grand theft, count 3, will be a $1,000 bond. Grand theft auto will be a $5,000 bond. The remaining 2 counts are no bond hold out of Miami. The bond in Broward County is $12,000 bond. If he does make that bond, then he will have a GPS monitor and pretrial release on top of it.
And Your Honor, we would ask for an order, no victim contact and no return to this community where the alleged incident occurred.
So done.
Thank you.
Thank you, Judge.
Thank you.
Your Honor, is that a complete house arrest that the court is ordering for anyone? Yes.
I'm sorry?
Is it house arrest that he's been ordered to
Yes.
leave his house?
Yes.
Call him later, it's an addition. I'll call him later.
Drug trafficking case?
Yeah.
We did it.
No, I'm gonna.
Rhianna McTeague.
North Broward.
McTeague. Rhianna. North Broward. Thank you. North Broward.
Deputy Nedry.
Oh, we still have to Netflix.
Yes.
Good morning. Do you have Rhianna McTeague there?
Deanna McKee. That's another medical reset.
Okay.
Jumping all over the place.
Set that for tomorrow morning. Dawn Aloya.
North Broward.
Dawn. A lawyer, yes.
Good.
Stand on the X.
Good morning, Ms. Aloya. You are charged with one count of violation of probation on a felony. Looks like it's possession of alprazolam. Based on the warrant, I do find probable cause. You're currently being held no bond. You will remain no bond. Looks like you have a violation probation hearing set for the 18th at 8:45 in front of your divisional judge. Good luck to you, ma'am.
The 18th, sir? You said the 18th?
18th, yes, ma'am.
You said the 18th?
Yes, ma'am.
Thank you.
Take care. Latoya Grant.
Miss Grant. Medical reset, Your Honor.
Okay, we'll reset that till tomorrow morning. Melissa Hill.
She's present here at Main, Judge.
Good morning, Ms. Hill. You are charged with two bond surrenders on a felony case and additional, counts 3 and 4, uttering a false instrument, and count 4 would be grand theft. I do find probable cause on all 4. You're currently being held no bond on the bond surrender. State was the Was it a violation? I can't tell whether it was a.
What happened on 1 and 2? She failed to appear, and then I believe the bondsman surrendered the bond, but it was a no bond hold on the failure.
I
to
see.
appear.
Okay. All right. So. All right, on counts 1 and 2, you'll be held no bond. Counts 3 and 4 is $1,000 apiece, total of $2,000 bond on counts 3 and 4. No bond on counts 1 and 2. Glad you know. Angeline Celestine.
All right.
Good morning, Ms. Celestine. You are charged in 8 counts. Count 1, false ID given to a law enforcement officer. Count 2, resisting without violence. Count 3, operating without a valid driver's license. Count 4, failure to register vehicle. Count 5, unlawful registration or tax registration, license plate not assigned, rather. Driving while license suspended as a habitual offender. Failed to provide proof of liability insurance. And 8 is a violation of community control on a felony. I do find probable causes to all 8 of them. On count 1, it'll be a $500 bond. Count 2, $500 bond. Count 3, $1,000 bond. Count 4, I'll remain as a 0 bond. Count 5, there will be a driving while licenses. Counts 4 and 5 will be a 0 bond. Count 6, driving while license suspended, habitual, will be a $1,000 bond. Count, $1,000 bond. 7 is a 0 bond. 8, you're being held no bond. So if you resolve 8, you'll have a total of $3,000 bond.
Sir, can I
I'm
say
sorry, I did not see
something?
count 9. Oh, there's an out-of-county hold, which is also, you're also being held no bond on that, I believe.
Sir, can I say something?
It's the same as a VOP case.
I don't recommend it, but I would talk to counsel before you said anything. I'm talking about the facts of the case, but if you have something to say that's not involving the facts of the case, because anything you say will be used against you, what do you have to say?
Can I get placed on house arrest or something?
No,
Because I don't have no money to afford the bonds.
Well, in this case, ma'am, even if I gave you house arrest on counts 1 through 7, you still have no bond holds on count 8 and 9, and I'm not inclined to do anything with those. So, best of luck to you.
Your Honor, may we call case out of turn? Xavier Alahad. He's on page 15. Charges are murder and felony.
Zavian Alhad, he's here present. I believe the Mr. Gabe Ermine is his attorney.
Yeah, give me 1 second. Let me just pull it up here.
Okay. Zavian Alhad, there's your attorney, sir.
Okay. Xavier Alahad. Good morning, Mr. Alahad.
Good morning.
Okay, Mr. Alahad, you're charged with murder, not premeditated during another felony, and robbery with a firearm.
Jack, I believe it's attempted. Count 2.
Yeah. In reading the probable cause, I believe, again, Cavius was attempted.
Yeah, because he did 21 days at the facility. They threatened about him.
Yes.
I did review the PC. I'm not going to make a PC argument. But I would ask the court to deny argument.
David Carroll.
Later in time.
You're David Carroll? Come up here.
That's David Carroll right there.
I just asked for some form of,
hey, when they do that, man, I'll just keep going.
I could always address.
Yeah, they don't want that. You keep right up. Looking right there.
Well, I do find probable cause as to both counts. After reading the probable cause affidavit, I am respectfully going to decline to set a bond. He'll be held no bond on counts 1 and 2.
David Carroll. You know his name.
Pending further bond inquiry in the division that he's currently assigned. It looked like an attempted robbery and 3 shots were fired. So. You'll be held no bond. Okay, thank you. Good luck to you, sir.
Your Honor, I apologize, but there's another attorney, Mr. Odom, handles some municipal ordinance cases. He's also present
Okay.
if you want to take it out or take those cases.
Sure. Where is he?
He's right in the front row. George.
I'm sorry. Apologize, Your Honor. Thank you.
No problem. What do you have?
Just two on your docket, Judge. Mr. Corey Johnson, he's on page 11 of your docket.
Okay.
And George Odom standing in on behalf of Mr. McLawrence's law firm.
Okay.
He's at the main facility. Judge, it's a city municipal ordinance case, so I know you are already aware of the state technically doesn't have a ball in the fight. What I'm going to ask the court to do, once he comes
Okay, let me call it Corey Johnson. Did you say he's in main jail?
He's according to the docket. Okay. Judge, first I'll
get resolved. Okay, what's up, Mr. Johnson?
And I provided an order to the court.
He's been locked up 14 years. Oh, Mr. Johnson. There's your attorneys right there. Hold on. Judge, who are we on?
Corey Johnson.
Corey Johnson.
Jory Johnson. Okay. Who? Jory Johnson?
Corey Johnson.
Oh, Corey Johnson. Corey. There you go.
And I wonder have we been appointed before I actually speak?
Yeah, I'll point. Yeah,
okay.
You're appointed.
Judge, second, and I heard him already speaking. I believe he was brought into the Everglades for the prison sentence. This is still outstanding because they won't release it until he gets this resolved. His expected release date was January 13th of 2017. So I think he's willing to resolve the time served progress.
Mr. Johnson, do you want to resolve this case today?
Yes, sir.
Okay. State.
Yes, Judge.
You need to know if something crazy doesn't do that shit. You need to know who
Yes, sir. Well, it's a municipal
Oh, that's
ordinance.
right. It's an MO. All right, Mr. Johnson, I understand that that this is holding you up from going to Florida State Prison. If you want to resolve this case today, I would adjudicate you, give you credit for any time you've served on this case. Is that something that you want to do?
Yes, sir.
Would you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you put your hand down, sir. Can you state your name, please?
Corey Johnson.
All right, Mr. Johnson. You heard what I said. I find probable cause for the open container municipal ordinance. If you want to resolve the case today, I would adjudicate you guilty, give you credit for the time that you've served on this case. How do you wish to plea?
Guilty.
Okay, I'll accept your guilty plea, and I will sentence you to an adjudication credit for time served.
All right.
Thank you, sir.
All right, thank you.
And last page 13 on the docket, last name is
Rhonda.
Main jail as well.
Karonda Ingram? Karonda Ingram? Karonda, on page 13, Karonda Ingram.
What's the name of the company you work for?
Judge, I've been advised Karonda Ingram bonded.
Okay,
That's all I have, Judge.
great. Thank you. Happy New Year. All right, Leslie Castro.
North Broward, Your Honor. Come on, Mr. Castro.
Good morning, Ms. Castro. You are charged with 2 violations of probation on separate felony cases. I do find probable cause as to both of them based on the warrants. You'll be held no bond until you see the division judge. It looks like you have a hearing set, looks like Thursday at 9 a.m. Good luck to you, ma'am.
What? To activate? Oh, for the.
You have a violation and you have aggravated battery. You have a court date on 1/12. We just told you.
112?
Yes.
At 9 o'clock?
At 9 o'clock, yes.
Is that a Gathers?
North Broward again, Your Honor.
Ms. Gathers, you were charged with 1 count of violation of probation on a felony charge. Looks like resisting with battery or resisting with violence. You're being held no bond. You'll be continue to be held no bond until you see the division judge on 1/12 of this year, which I believe is Thursday at 8:30 a.m. Good luck to you, ma'am.
Thank you, sir.
Judge Kiner. I had one more female up here that you skipped on page 5, Michelle Clark.
Yeah, I put her on recall because we didn't have her up. Oh, that's right. Her attorney's not here yet. Do we have a notice of appearance or anything?
She represented her in prior cases. In speaking with Ms. Clark and getting her ties to the community, she told me that Ms. Tomanakis is her lawyer.
Okay.
So as
I'm gonna call her.
Ms. Clark.
Yeah, Michelle Clark.
Can't stand on the X.
Ms. Clark, you are charged with 2 counts. First is resisting an officer without violence, and second is trespass on property, not a structure or conveyance. I do find probable cause to go to the state. Does he have prior?
One moment, Your
Judge, one thing I gathered and learned in talking to her, the address where she was trespassed at is on the Seminole Reservation. She resides there with her girlfriend. Now, the person who issued the trespass is deceased. The property was thereby transferred to her to her girlfriend's sister, who has no problem with her living there. So there are certain issues in the case that she relayed to me, and while in speaking with her, I know I'm not arguing probable cause, but I'm just saying that there's just on the face of the PC there's enough. But I think she may have defenses later on down the road. I would ask the court to take that in consideration and setting bond in the case.
Do that.
Okay. Picked up 2013 in Hillsborough County on a failure to appear. Theft, Hillsborough County, and possession of controlled substance, 2013. She was sentenced to a year and a day state prison. One moment, Judge. Possession controlled substance, introduction into detention facility, 2010 out of Miami-Dade.
All right. I find probable cause. I'm going to set bond in the amount of $500 on each one of these counts.
Just with the court, I understand the court. Miss Tomanakis did tell me that she was coming, but the court do without prejudice until she gets this hold off on setting the bond until she gets here.
I mean, we're already at 9:15. I don't know that Ms. Samanakis is going to be able to tell me anything.
She will.
That is going to change her mind on bond. I think in the overall scheme of things, given her record, it's a fairly low bond.
I didn't get charged with that.
You didn't get charged. He told you got charged with resisting and trespassing.
Yeah, but they're saying these charges from 2010.
Monique Clark.
Paul Ryan.
Ms. Clark, you are charged with 6 counts. First one is fraudulent use of an ID of another person without consent, and then counts 2 through 6. There's possession of a fictitious or unlawfully issued driver's license. I find probable cause as to all 6. Your bond on each one of the counts is $1,000, which for a total of $6,000. Good luck to you, man.
Yeah, one second.
Rosette.
How do you pronounce your last name?
Ogjenner?
Ogjenner. She's here at Maine, Judge?
Okay. Ms. Ogjenner, you are charged with 1 count of grand theft. I find probable cause. Bond is $1,000. Good luck to you, man.
Judge, in speaking with Ogjenner, she's been residing in South Florida for the past 17 years. She's currently employed. She works at Bolton Medical Care as a nursing assistant. She's been employed doing that for the past 4.5 years. She makes only $10.75 an hour. Judge, she has 2 children, ages 13 and 12, that she takes care of. She takes to and from school. She has no money in the bank, no property. This is her first arrest ever. If the state could verify it, she is a registered voter. She serves in our community. She's been attending the same church for the past 17 years, Mercy Divine Catholic Church, which is in Fort Lauderdale. She's in the choir. If the state can verify this is her first exposure to the criminal justice system, considering her ties to the community, we'd be asking you to consider an ROR.
I see a grand theft from 2002.
And she was.
We didn't hear.
2000, another theft in 2002. She was adjudicated on that one.
Okay.
She's had 2 prior thefts next door.
Respectfully, I'm going to leave the bond where it was set by the original judge.
Thank you, Judge. I apologize.
Carrie Vidal.
Okay.
Carrie Vidal.
Carrie Vidal? Carrie Vidal? Bonded? Judge, I've been advised Carrie Vidal bonded.
Tony Carlisle.
Page 11. Mr. Carlisle is here present. It's a municipal ordinance case. As a friend of the court, Mr. Carlisle is inquiring if you consider resolving his case.
State priors.
Your Honor, do you have his BCCN number on top of the booking sheet? Be at the top of the
His BCCN is 776768.
Your Honor, his last arrest was May 3rd of last year. That was a trespassing. He pleaded out, received a withhold. Prior to that was just October 2014. That was on a VOP on a grand theft.
All right. Mr. Carlisle, if you want to resolve your case today, I'd adjudicate you guilty, give you credit for time served. Is that something you want to do?
Yes, sir.
Okay.
Yes, sir.
Could you raise your right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down. Could you state your name, please?
Sir?
Can you state your name, please, for the record?
Tony Carlisle.
Okay, Mr. Carlisle, you're charged with a violation, a municipal ordinance violation, an open container. I indicated to you if you want to resolve the case today, I would adjudicate you guilty, give you credit for time served. Is that something you want to do?
Yes, sir.
Okay, how do you wish to plead guilty or no contest?
No contest.
Okay, I'll accept your no contest plea. I'll adjudicate you guilty and give you credit for time you've already served. Good luck to you, sir.
Thank you.
Maxius Ernest.
Yes, Your Honor. Good morning, Your Honor.
Good morning.
Mr. Ernest is present here at Maine. Your Honor, respectfully, Mr. Ernest is asking if you would consider resolving his case at time served.
And, Your Honor, I would ask that the matter not be resolved since it involves a private citizen's property and they may wish to be heard.
Mr. Ernest, you are charged with trespass, property, not a structure or conveyance. If you find probable cause, the bond is currently $25. I'm going to leave the bond in place where it is. It involves potential of a private residence, and I think they have a right to be heard prior to sentencing.
Thank you.
Joshua Moody.
What? Oh, it's...
Mr. Moody is here present.
Mr. Moody, you're charged with domestic violence battery. I do find probable cause. State doesn't have...
One moment, Your Honor. Actually, Your Honor, I'm going to check, but I think this was filed as a strangulation.
It is.
Okay, yeah, I know it says battery on the left on the charge. And... Okay, Your Honor, I'm showing 2011 out of Clay County, uttering a forged instrument, false ownership info to a pawnbroker, grand theft firearm, and trafficking stolen property. He was sentenced to a year in a day state prison.
Defense? Anything?
Judge, in speaking, Mr. Moody, he's been residing in the state of Florida for 33 years. He's from Jacksonville. He's employed. He works for Enviroscape Landscaping Company. He's been working for them for the past 6 years. He makes approximately $350 a week. He has no money in the bank, no property. He does have his HVAC license. Judge, we'd be asking you to set a reasonable bond as to Mr. Moody.
Okay. Under the circumstances, I do find probable cause, and I set bond in the amount of $5,000. Luck to you, sir. No contact with the victim.
Don't put that. Just put your vote. Take the picture.
11.
David Carroll.
Mr. Carroll, come on up. David Carroll. Mr. Carroll, Judge, is hard of hearing. I believe he can only listen from his left ear, so I'm going to try and tell him what you tell me.
Sure.
But he does, as a friend of court, and speaking to him, he does wish to resolve his case today.
Mr. Carroll, you're charged with one count. It's a capias on a misdemeanor. Based on the capias, I do find probable cause.
You're here for a capias on a disorderly conduct. He found probable cause for it.
Bond is set at $500.
Bond is set at $500.
Based on the information received in the probable cause affidavit, I'm going to decline to resolve the case today, and I'll let the divisional judge handle it. Good luck to you, sir.
Based on the information in the probable cause affidavit he read, he's declining to resolve the case today, all right? So you're going to have to talk to your division judge and your attorney in the courtroom. So today, at this time, it's a $500 bond, okay? Okay. Thank you, sir.
Judge, I have on page 20 at the very top, Cameron Black. First words I've said all day.
Who are we calling?
What page you on?
I don't know. Oh, page 20?
Page 20, Cameron Black.
Cameron Black, come on up, please.
Okay.
Your attorney's in the courtroom, Cameron Black?
Good. Mr. Black was actually in my office yesterday, I guess about an hour before it looks like he was arrested. If you look at the probable cause affidavit, Judge, I do have some issues with the fact that this officer, Mr. Danny Fuller, says that he comes up as backup and smells the odor of burnt cannabis. If he's coming up as backup, that means another officer's already been present and probably sitting there for a little bit. I doubt that officer's allowing this group of individuals to smoke marijuana. And knowing yesterday's windy conditions, that smell of burnt cannabis would probably dissipate. The second thing is that the other thing they find on Mr. Black is a badge that is underneath his person. I think it's his person, just is directly underneath him, which I'm not quite sure I understand what that means. And then some small residue in his gloves. As I shook Mr. Black's hand yesterday with those gloves on, the cotton gloves, and you could see on the gloves, just by the very nature of the gloves, that they pick up, anything. I mean, other pieces of clothing on there, probably debris. Sitting outside, I believe they were on the sidewalk, just hanging out. Anything that he puts his hand down is going to probably get attached to that glove. He was actually supposed to be in court this morning, Judge, for probation status to make sure that everything's going well with his day reporting. We took that plea in front of Judge Shear about 2 or 3 weeks ago. He's allowed to be in Broward County. There's nothing stopping him from being in Broward County. I don't understand why they're saying he can either be at his aunt's house or work. He's got Tri-County travel. He lives in Palm Beach County. Your Honor, I understand counsel's argument. I do believe The PC has written that there is probable cause at this point. I would also note that Mr. Black's been on probation for about 18 days for possession of cannabis with intent to sell.
Yeah, Mr. Shade, I mean, based on the probable cause affidavit, I do find there is probable cause. His bond is $100 on count one. And given the fact that it would form, just in light most favorable to Mr. Black, it would still violate his probation. So he's got a current BOP date of the 18th. I'm going to leave it there, and I count two will be no longer until.
Okay. Mr. Black, he's supposed to be in court today. I'm gonna go over. He's supposed to be in court today. I'm gonna go over to Judge Shear right now and see if we can make that 18th date a little bit sooner. Okay?
Could you say that again?
Yeah, what he's going to do, sir, is he's going to go and talk to your divisional judge and see if they can't move up the violation probation date. Okay, so potentially if it gets resolved, you're out earlier. You understand?
Yes, sir.
Okay. Mr. Shade will be in touch with you, sir.
Thank you, Judge. Take care. If you leave before me,
All right, thanks.
Thank you.
Thanks, sir. Take care.
Mark Okerman.
Mr. Okerman's here present. Judge, Mr. Okerman declined to serve as a public defender. He advised me that he has private counsel, Daniel Rose.
Okay. All right, Mr. Okerman, you are charged with one count of violating an injunction. I do find probable causes to that. State, does he have priors?
Your Honor, I am showing no priors.
Any recommendations, State?
One moment, Your Honor. Your Honor, I'm going to be asking for a $2,500 bond. However, I'm also going to be asking for a GPS monitor since now he's allegedly violated a court's order, to serve as a reinforcement to make sure it's not violated again.
Sir, I find probable cause in your case. I am going to set bond in the amount of $5,000. I am going to decline at this point to put you on a GPS monitor, given the fact that you have no prior history. However, sir, I can't stress upon you enough that if you violate the terms of this this bond, you are likely looking at a no bond hold. You've already violated one court order not to have communication with this particular person. Hopefully this gets your attention. The bond will be $5,000, no victim contact whatsoever.
Okay, Your Honor. Okay.
Mark, now.
Mr. Ganau is here, President Maine. Judge, he's advised me if you would consider resolving his case as time served.
Mr. Ganau, you are charged with 2 counts: disorderly conduct and trespassing. You find probable causes to both.
Take medication, mental problems, you were arrested. Okay, thank you.
State, priors?
One moment, Your Honor. I got one prior. I don't have anything. Do you have anything? I'm not showing anything, Your Honor.
Okay. Mr. Ganau, if you want to resolve your case today,
I'm just going to check one other database, Your Honor, just to make sure. Okay. Your Honor, there was a theft last year. I didn't see it at first. It was out of South Satellite.
Okay. All right, Mr. Ganau, if you want to resolve your case today, I would adjudicate you guilty on both counts, give you credit for time served, if that's something you want to do.
Yes, sir.
All right, sir, can you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You put your hand down. Can you state your name, please?
Mark, no.
Okay. And Mr. Nah, you understand that if you want to resolve your case today, I will adjudicate you guilty, give you credit for time served on both counts.
Yes, sir.
That means a conviction on your record. You understand that, sir?
Yes, sir.
Okay. How do you wish to plead, guilty or no contest?
Guilty.
All right. I'll accept your guilty plea on both counts, and I'll adjudicate you guilty for credit time served on both counts. Good luck to you, sir.
Thank you, sir.
Do not return back to this place of business. That place of business.
No problem.
That is Publix in East Hallandale Beach Boulevard. Okay?
Yes, sir. Yes, sir.
No return.
Okay.
All right.
Mr. Watson.
Ricardo DeLees.
Ricardo DeLees?
Mr. DeLees, you are charged with 2 counts. One count is leaving the scene of an accident involving damage to property. The other is driving while license suspended without knowledge. I do find probable cause as to both of them. State, does he have any priors?
One moment, Your Honor.
He was arrested on a felony drug charge.
What is his BCCN number, Judge?
His BCCN is...
Okay. Your Honor, I'm showing he was arrested November 8th of last year on a drug charge. Filing decision has not yet been made. Felony level 2015, leaving the scene of an accident with a no valid DL.
Yes, sir. I do find probable causes to both counts. On count 1, your bond is going to be $5,000. Count 2 is a 0 bond. Lucky, sir.
Judge, you said on count 1, $5,000 bond?
$5,000 on count 1 total.
Judge Kiner, Webb Christopher was at North Broward. Come on.
James Hancock.
What page is he on?
You skipped over him. He was right before DeLees, Ricardo.
Did I?
I think we might have skipped over a few.
Thank you, Ned.
Yeah.
We have Hancock.
I'm getting very confused up here.
You're more confused than I am. I must have put you back in a different order or had them out of order. Let me just check. Did I? Is it attached?
It might be here.
Webb? Yeah, here, I got it. I'm sorry. All right, Christopher Webb.
Judge.
You are charged with 1 count of trespass to property, not a structure or conveyance.
Judge, he would like to plea out. He would like to resolve the case to time served if the court is so inclined.
Priors?
He has a pending theft before Judge Gottlieb.
Yeah, I'm gonna decline to offer a plea. I'll let him go in front of Judge Gottlieb.
I'm with a friend right now.
I can tell you, just trying to see who. Yeah, it looks like he has the PD on the theft case.
All right, I'll appoint the public defender's office on this case. I'll leave his bond where it is at $25.
Judge, we had 2 previous gentlemen before Mr. Webb.
Sure.
James Hancock and Alan Uribe on page 12 of your docket. And they're both located here at Maine.
Okay.
James Hancock?
All right, Mr. Hancock, you were charged with 1 count of petty theft. I do find probable cause. Pages, you have priors?
Your Honor, he's registered.
Oh, okay.
He's got an outstanding warrant out of Georgia also on a probation violation connected to the underlying offense that he's registered on.
Okay. All right, I do find probable cause on the petty theft. I'm setting bond in the amount of $1,000. Good luck, you, sir.
Okay, that's all.
Alan Uribe.
Mr. Uribe, come on up, please. 12.
Mr. Uribe, you're charged with 2 capiases. I find probable cause based on the capiases. They are for misdemeanors. Looks like arising out of the same case. One is petty theft and one is trespass. Do you want to resolve this case today?
Let me ask him, Judge. Mr. Uribe.
Pardon? Yeah, of course.
Your Honor.
We're going to take a brief break. All right, we're back on. Alan Uribe.
Yes, Judge. He's going to be. He wants to have his day in court on this case. So.
Yeah, no, that's no problem. Okay, sir.
Thank you, Judge.
A $250 bond on each one of these counts. So it's a $500 bond on this case. Good luck, sir.
The only thing we'd ask is if you could sign a phone order allowing him access to his property so he can call someone to post his bond.
Sure.
Thank you. Nicholas Goldsmith, I believe you're next.
Yeah. Nicholas Goldsmith.
How you doing?
How you doing? Sir, you're charged with 2 counts. One is resisting an officer without violence. The other is trespassing. Your structured conveyance. I find probable causes to both of those. Your bond on count 1 is $100. Count 2 is 0. So it's a total of $100 bond.
Judge, Mr. Goldsmith advised me he's financially indigent. He is homeless. He's asking if you would consider resolving his case today for time served.
Your Honor,
Yes,
Mr.
he does have
Goldsmith was arrested. I just need to see what's happening in this case.
Take medication? Mental problem, you're arrested?
He was just recently released on a ROR and a 30-day motion. A final decision has not been made. Charges of aggravated battery and a law enforcement officer, possession of cocaine, drug paraphernalia, resisting with violence, resisting without violence.
I'm going to leave. I'm going to let the division judge make that decision. Bond.
Thank you, Judge.
Christian Campo.
All right.
Campo, you're charged with 1 count of habeas on a felony. Excuse me. I do find probable cause.
It's, Your Honor, just an add charge to his original burglary arrest.
Okay, that makes sense. I was it's charged too. Okay. Your bond on this count, sir, is $25. Good luck to you, sir. You have a status set for the 17th at 8:30 in the morning. Taylor Wesson.
Mr. Wesson is here present at me.
Mr. Wesson, you are charged, I guess it's count 7, with robbery with a firearm. I do find probable cause based on the probable cause affidavit, and you are being held no bond. Good luck to you, sir.
That's for no victim contact, Judge?
No victim contact.
Thank you.
It's a new bond.
Just abundance of caution.
Angel Rivera.
Mr. Rivera, come on up, please.
Sure.
Mr. Rivera was here yesterday, Judge. I believe these are maybe add charges?
Yes.
All right. Yeah, Mr. Rivera, what was count 1?
It was a domestic violence battery that was heard yesterday. Bond. One moment, Judge. Bond was set at $20,000 plus pretrial release with a GPS monitor. He had it was a felony battery yesterday.
That's fine. Sir, I do find probable causes to counts 2 and 3 here, and I set bond in addition to the $20,000 bond on count 1 and all the conditions that have been previously set on count 1. I set $5,000 bond on count 2 and a $5,000 bond on count 3. So you'll have a total, I guess, of a $30,000 bond plus a GPS monitor, no victim contact. Lucky, sir.
Thank you, Judge.
Thank you. Daniel Haggerty.
Judge, Mr. Haggerty is here present. He declined the services of public defender.
Well, Mr. Haggerty, you're charged with 3 counts. First is battering a law enforcement officer or firefighter. Count 2 is resisting an officer with violence. Count 3 is resisting without violence. I do find probable causes to all 3 counts. Count 1, your bond's going to be $5,000. Count 2 will be $2,500. Count 3 will be $1,000 for a total of Michael Bowen.
Mr. Bowen, Michael Bowen, come on up, please.
Mr. Bowen, you're charged with 1 count of aggravated assault on an officer.
Judge, Mr. Bowen declined the services of public defender.
have children?
Yeah, I made a note to myself on this. I wasn't sure whether there was an aggravated part of this.
One moment, Your Honor.
This assault
It's,
conduct.
well, Your Honor, looking at the arrest sheet, it's a misbook. The officer just wrote assault.
I'm sorry.
On the arrest form, on the PC affidavit, the officer just wrote assault. I think it's a misbook.
Yeah, I believe it is too, because I looked through this probable cause affidavit this morning and I did not see.
Yeah, I mean, I'm just,
aggravated.
I'm just looking at the offense charged on the PC affidavit.
So, I do find probable cause as to an assault.
Do you have an attorney? I'm sorry? I'm with you. Fifth Amendment. I'm sorry? Do you have any children?
And I set bond in the amount of $1,000.
Thank you, sir.
You take some time.
Thanks.
How much do you for?
Orion Green.
Mr. Ryan Green is here present, Judge?
Mr. Green, you're charged with 2 counts. First is a battery, and the second is burglary of an occupied dwelling unarmed. I do find probable cause as to both. Does he have priors?
One moment, Judge. Your Honor, I'm getting hits out of, trespass in 2010 in Nevada, failure to stop for law enforcement, reckless operation of a motor vehicle, 06 out of Massachusetts, and out of Texas, that's just a traffic offense. An arrest for battery in 2001 in Alachua County that was dropped.
All right.
End of record.
Green, on count 1, I set your bond in the amount of $15,000. On count 2, I set your bond in the amount of $15,000. If you are to bond out on those charges, then you will be on a GPS monitor. No contact with the victim.
You mean, depends on what he does.
House arrest with the GPS monitor. All right.
Check.
Luck to you, sir. Charles
Thank you.
Mr. Rashadi, you are charged with 1 count of violation of community control on a felony charge of find probable cause. You're currently being held no bond. You will remain no bond. You have a hearing set currently for the 17th at 8:30.
Thank you. Judge, I believe we may have skipped. Oh no, we haven't. Sorry, I apologize.
No problem. It would be just as likely that we skip somebody for today. Okay, Angel Garcia.
Mr. Garcia, come on up, please.
Mr. Garcia, you're charged with excuse me, 2 counts of violation of community control on felony charges. Looks like the possession of alprazolam and possession of cocaine. If you find probable causes to both of them, currently being held no bond, you remain no bond. You have a violation of community control hearing set for the 12th at 9 a.m. Good luck to you, sir.
If you want, it's gonna be.
I'll email. Want to email them?
How long you live in South?
DeVoris Walls.
North Broward. Yes, sir.
Mr. Walls, you're charged with violation of community control on a felony charge. It looks like burglary with an assault or battery in front of Judge Singal. I do find probable cause as to that charge. You're being held no bond. You'll remain no bond. You do have a violation of community control hearing set for the 17th at 8:30. Good luck to you, sir.
All right, thank you.
Andrew Flowers.
Hill. 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 Stop up there. Come on.
Anthony Flowers is here present.
Okay. Mr. Flowers, you're charged with 2 counts of violation of probation. Looks like possession of TBC and possession of cocaine. I just found probable causes to both. You have a violation of probation hearing set for 112. You're being held no bond.
You'll be seeing your judge January 12th at 9 a.m., okay, sir? All right.
Harvey Moise.
Harvey Moise. Oh, is that medical loan? Medical loan, Judge.
Okay. You set that for tomorrow morning.
You were arrested by yourself?
Savon Jackson.
Mr. Jackson?
Mr. Jackson, you
Judge, he advised me that he declined to serve as a public defender.
No problem. Mr. Jackson, you were charged with violation of probation on a felony. Count 1, count 2. Looks like home invasion with a firearm, other deadly weapon. I do find probable cause on both of them. You'll be held no bond. You have a hearing for your violation of probation on the 17th at 9 a.m. Good luck to you, sir.
And no victim contact in abundance of caution?
Yeah. No victim.
Thank you.
Yes, sir.
Because you want Albert Cahill.
North Broward.
North Broward.
Morning, Mr.
Javante
Cahill.
Singletary, you're next. Javante Singletary? Oh, he bonded. On a VOP? Oh, it must be financial then.
Mr. Cahill, you are charged with 2 counts. One is grand theft, and the other is a warrant on a felony. I do find probable causes to both. Count 1, you're being held on a $1,000 bond. Count 2 is a no bond hold. You have a hearing set for the 17th at 8:30 a.m. Good luck to you, sir.
What do you say? I couldn't hear him.
Javante Singletary
Judge, I've been advised he bonded.
on a robbery with a firearm.
And she was an ROR.
It was an ROR, Judge.
Not sure why we issue a warrant with an ROR on it. Okay. All right.
Yeah. You want me to call Yes,
Rommel Mendoza.
Judge, we're going to need a Spanish interpreter for Mr. Mendoza.
Okay, I'll put him on recall.
Toma asiento, por favor.
James Krantz.
James Krantz.
Morning, Your Honor.
Mr. Krantz.
All right, thanks.
Give me 1 second. Mr. Krantz, you were charged with 2 counts. First is petty theft. Looks like third or subsequent offense. Count 2 is possession of cannabis, 20 grams or less, which is a misdemeanor. Both of them. I do find probable causes to both. Count 1 is $750 bond. Count 2 is a 0 bond. Good luck to you, sir. Jaheim Richardson.
Mr. Richardson, come on up, please.
Mr. Richardson, you were charged with 1 count of burglary of an unoccupied dwelling while unarmed. I do find probable cause.
Judge, I would argue, even in the PC, it says it's an attempt, which would reduce it to a third-degree felony.
Well, he entered the curtilage. Fortunately, I apparently have a better understanding of the law than the officer, but he jumped into a fenced-in backyard.
Yeah, I find probable cause to the completed act once he jumps into the curtilage with the intent. Any priors on Mr. Richardson?
Yes, Judge. 2013, out of Palm Beach, armed burglary, grand theft firearm, possession of firearm or ammunition by an adjudicated delinquent, and grand theft. He was sentenced to 4 years state prison. He was released from state prison December 3rd of last year.
2016?
Yes, Judge. It would appear everything else would have been as a juvenile, but I can tell you, as a juvenile, he had 3 priors immediately connected to this offense.
Mr. Richardson, I find probable cause as to the burglary, unoccupied dwelling. Yeah.
In speaking to Mr. Richardson, I'd ask you to consider that he's been residing in South Florida for his whole life. He's 22 years old. At this time, he's unemployed. He's looking for work. No money in the bank, no property. He does live with his mother in Fort Lauderdale. They've been residing at the same residence his whole life, so he does have ties to the community. We'd ask you to set a reasonable bond considering his circumstances, Judge.
Well, under the circumstances and given the fact that he got out of prison a month ago for similar type offense, I think a reasonable bond is $15,000. So bond is set in the amount of $15,000. No victim contact.
Yes, Judge.
Thank you, sir. Darren Smith.
Mr. Smith, come on up.
Mr. Smith, you're charged with burglary of a dwelling or a structure. Armed?
Yeah, Your Honor, this is a misbook again. On the PC, it's listed as unarmed.
Yeah.
I would, assuming the court finds probable cause for burglary dwelling, though, I would ask the court to take into consideration the allegation that he threatened to kill the witness upon exiting the residence.
All right, sir. I don't find. I mean, it looks like on even the probable cause affidavit, it's unarmed. It should not be armed because there's no indication that he was armed.
You don't book anyone. No, it was
armed himself while in the dwelling. So I don't find probable cause as to the armed portion of that. I do find probable cause as to the burglary dwelling and priors.
Yes, Judge. 2013, unlawful use of false name ID, disorderly conduct. 2011, resisting without violence. 2012, felony battery, great bodily harm with a violation of probation. 2010, 2 counts of battery with a violation of probation. 2010 battery. He has an outstanding warrant at a Miami-Dade for failure to appear in court on a DWLS. He's got a $7,500 bond on that warrant. And one moment, Judge. Your Honor, get a trespass in Dade 2012, theft in Dade 2012.
Recommendations?
Judge.
Your Honor,
I'm sorry. Give me 1 second.
Your Honor, and even though he wasn't charged with it, Your Honor, I'm going to be asking for a $25,000 bond on one. I believe these allegations, and it'll be up to a case filer, but these allegations would support a punishable by life burglary with assault charge. Also, with the alleged threat to kill, I'm going to be asking for a GPS monitor, no victim contact, Your Honor, and no contact with any witnesses.
Judge, speaking with Mr. Smith, he's been residing in South Florida his whole life. He is 26 years old. He is employed. He works at Fat Tuesdays as a cook, making only $10 an hour. He just obtained that employment. He's been working there for 2 weeks. Financially, has no money in the bank, no property. He lives in Miami Gardens. He's been residing at the same apartment for 1 year. Considering his financial circumstances, we would be asking you to consider a $10,000 bond for count 1.
All right. Based on all the probable cause affidavit as well as the information that both attorneys have given me, I will set bond in the amount of $10,000 on count 1. Count 2 will be a $500 bond. Count 3 will be a $1,000 bond. Total $11,500 with a GPS monitor, no victim contact, house arrest.
Thank you, Judge. York Scott, come on up, please.
York Scott?
He's here, present, MA.
Okay, Mr. Scott, you are charged with 8 counts. Count 1 is possession with intent to deliver or manufacture cannabis. 2 is introducing contraband into a detention facility. 3 is resisting an officer without violence. You have 2 violations of community control for counts 4 and 5. Count 6 is possession with intent to deliver or manufacture cannabis. Count 7 and 8 are violations of community control and felony. Oh, I see. Okay. All right. I find probable cause as to all of them. Count 1 and 2 is $1,000 apiece. Count 3 is $100. Count 4 and 5 is a no bond hold. Count 6 will be $100. I'll reduce it from $1,000. Count 7 and 8 are no bond holds. You have a hearing set for the 12th at 8:45. Good luck to you, sir.
Thank you, Judge.
Excuse me, Judge. Good morning, Judge.
Good
morning. My name is Ray Rapagli. I'm the director of JC's Recovery House. Judge Davis texted me this morning to let you know he was up in Orlando, and I came on behalf of someone who you've already set a bond for,
Okay.
Daniel Haggerty, and I was wondering if I could approach the bench or talk to you about it real quick right now.
Let me do this. I would be happy to talk to you. I want to get through some of these because I've got a bunch of people
No
waiting
rush.
for me, but I'm happy
You
to talk
let me know,
to you.
sir.
Okay, thank you.
Thank you, Your Honor.
Eric Reese.
Mr. Reese, Eric Reese, come on up, please.
Mr. Reese, you're charged with 2 capiases, one on a felony, one on a misdemeanor. I find probable causes to both. On count 1, you're being held no bond. Count 2 is a $2,000 bond. Good luck to you, sir.
That's it. January 12th, 9 a.m. You'll see your judge. Joe Watson.
Joe Watson.
He's here, President Maine.
Mr. Watson, you're charged with 1 count of violation of probation. I find probable cause. Your bond on that case is set at $2,500. You have a hearing set for the 17th at 8:30. Good luck to you, sir.
All right.
Joaquin Johnson, come on up, please.
Joaquin Johnson.
Matt.
Sir, you're charged with 3 counts. First count is burglary of a dwelling unarmed. Count 2 is grand theft, and count 3 giving false ownership info to a pawn shop. I find probable cause as to each one of them. State fires.
One moment, Judge. I'm not showing anything. I don't know if pretrial has anything. Joaquin Johnson.
All right, sir, on count 1, your bond is going to be $5,000. Count 2 and 3, $1,000 apiece for a total of $7,000. No return to the residence, no contact with the victim.
Judge, if the defense could be heard, and speaking Mr. Johnson, I believe the state did verify that Mr. Johnson has no prior contacts with the criminal justice system. He is 18 years old. He's been residing in South Florida his whole life. He is looking for work. He goes to night school at Piper High School. He has no money in the bank, no property. He lives in Lauderhill, an apartment with his mother. They've been residing at the same location for the past 8 months. Judge, considering he's been residing in our community his whole life, no prior contact, he has no sort of financial ability to post bond, would you consider pretrial release if pretrial can verify his address?
And, Your Honor, the state would be objecting to straight pretrial release on a burg dwelling, secondary felony, breaking into someone's home. I don't even know that under Florida statute he's allowed to be released ROR to pretrial on a burg dwelling.
Then we would be asking you to set a $100 bond and with pretrial, Judge.
Your Honor,
Let me hear from pretrial.
yeah, sure.
Yeah, I'm going to let you make that argument to the division judge respectfully. He entered through a window.
Then would you consider lowering the bond from $5,000 to $1,000, Judge?
Not at this time. It's $7,000 total.
Thank you, Judge.
Keon Mack.
Mr. Mack is here present.
Mr. Mack, you're charged with driving on a permanently revoked driver's license and improper left-hand turn. I do find probable cause. Your bond is $1,000 on count 1. Count 2 is infractions, and there's no bond. It's zero.
Thank you, Judge. Like that one. Nazim Ford?
Oh, okay. Let me,
oh, okay. Interpreter.
Mr. Mendoza, Rommel.
Mr. Mendoza? That's fine.
Eso me puede ayudar con pretrial. Eso me puede ayudar con un programa.
¿Tienes dirección? ¿Tienes?
Sí, tengo dirección y todo eso.
¿Dónde vives?
Yo 5806.
We can't hear the interpreter, Judge.
Okay, we'll speak up. All right, Mr. Mendoza, you were charged with petty theft as a third or subsequent offense.
De acuerdo, señor Mendoza. Usted se le acusa de hurto menor como tercero o más delito.
I do find probable causes to that count.
Fallo que hubo fundamento de hechos para ese cargo.
Your bond is set at $750.
Su fianza la han fijado $750.
There'll be no return to the Home Depot at 1951 South State Road 7.
No podrá regresar al Home Depot que queda en la 1951 de la Sur Calle 7.
You speak English, you know about it.
Okay. Good luck to you, sir.
Thank you.
That's all we have, sir. Thank you. It's good seeing you. Nazim Ford.
Okay, thank you.
This morning. Mr. Ford, you were charged with 5 counts. The first being grand theft. Second is fraud and attempt to use an ID of another person. Count 3 is possession of a blank or fictitious issued driver's license. Running a red light and altering a license plate. I find probable causes to all 5 of them. Count 1, your bond is $1,000. Count 2 and 3 is also $1,000. Count 5 is $25. Your total bond is $3,025. Good luck to you, sir.
Judge, the only thing we'd be requesting is a phone order.
Granted.
Thank you.
Taylor Bechtel.
Mr. Bechtel's coming up, Judge.
Good morning, Your Honor.
Good morning. How you doing?
I'm doing all right, thank you.
Okay, Mr. Bechtel.
Judge, he declined to serve as a public defender.
Okay, no problem. Mr. Bechtel, you're charged with 4 counts. The first is operating with unsafe or improper equipment. Count 2 is excuse me, improper non-working tail lights. Counts 3 and 4, possession of cocaine and possession of MDMA or ecstasy. I do find probable causes to all the counts. Counts 1 and 2 are traffic infractions that don't carry a bond. That's zero bond. Counts 3 and 4 are $1,000 apiece. Your total bond is $2,000.
Your Honor, can I note that I have been a member of the community for about 27 years. I've never lived anywhere else, and recently have started my own business selling art. I'm an artist, a struggling artist, so I don't have a lot of finances available. Would there be any way to request a lower bond amount?
Well,
I don't know. Like I said, this is my first day here about it.
Was this a...
It's not in custody. It's not from a factory. So it's a misdemeanor drug priors in the past.
Okay. Go ahead. I'm sorry. Okay. This is what I'm willing to do, sir. If pretrial release is able to verify your address, they'll come and interview you. If they're able to verify your address, then I will release you to pretrial services. Right now, we'll leave your bond at $2,000, but if pretrial services can verify and accept you, then I'll release you ROR to pretrial. You understand?
Yes, sir. Thank you, sir.
Okay. Okay, so I'll just ROR to pretrial.
No, just put pending verification on your file.
Okay.
That's all you got? As soon as you get out there, that address for the area.
Okay.
Judge, can we do a gentleman out of order, Calvin Whiting, on page 25?
Sure. Give me 1 second.
Thank you.
Calvin Whiting. I'm not sure I have. I don't have his.
This is a gentleman that's been on reset for several days.
Okay, let me.
Calvin Whiting, on page 25.
Maybe it's left.
I don't have his paperwork. Is he present?
Yes.
Give me 1 second, because I did not have his paperwork. I need to.
Why can't we just do this? Who is this?
Who's this?
Calvin Whiting, page 25.
Oh, okay. Got it.
I have Michael Rich. That's the last one I have.
Calvin Whiting? No, he's being held no bond on. He had a pending carrying concealed firearm that he's being held on, and he violated his pretrial.
Oh, I see. Pardon? All right. Okay, Calvin.
You ready on Mr. Whiting?
Yeah.
Okay, Mr. Whiting. Calvin Whiting, come on. The judge, he declined to serve as a public defender.
It's gonna be one of these. Don't have one in your house.
Mr. Whiting?
Yeah.
Shift work.
Mr. Whiting, you are charged with, I guess it's count 12. I guess you have 11 other counts at least. Of burglary, unoccupied dwelling, while unarmed. After reading the probable cause affidavit, I do find probable cause for that count. State.
Your Honor, I would need to. Do you want a priors or a recommendation? Judge, unfortunately, I passed the paperwork along on him before. He was reset so many times, I don't even...
All right. I mean, in looking at the probable cause affidavit, it does appear that it has other charges pending. I'm going to set bond in the amount of $15,000 on this count. No return, no victim contact.
Just for the record, he does have a public defender.
Rich, you right next to the white, right next to let her get him.
Take who now?
He's yours. Try to get him.
He going with us? Okay.
Let him see if you can see him next.
Okay.
You have an address now? Comes from the information.
Cameron Hobby.
Bonded.
Oh, Judge, I've been advised he bonded.
Okay.
Judge, and also, could we do one other? They're requesting the deputies, Mr. Michael Rich on page 25.
Okay. Mr. Rich, you were charged with 2 counts. 1 count of grand theft auto, 1 count of resisting without violence, and find probable cause. As to both of them, count 1 is a $1,000 bond, count 2 is a 0 bond. So your total bond is $1,000. Good luck to you, sir.
Thank you.
Who do you have next? I have Junior Francois. I got all out of order.
Junior Francois is here, present.
Okay, Mr. Francois. You're charged with 1 count of violation of probation on a felony charge. I do find probable cause, being held no bond, remain no bond until your VOP hearing is set for the 17th at 8:30. Good luck to you, sir.
Davila Rodas, on page 22. Did he bond? He bonded?
Okay, Santiago Rodas Davila.
They're looking it up right now, but we believe he may have bonded on page 22. He bonded, Judge.
Okay, thank you.
Elijah Ramanor, I've been informed Elijah Ramanor bonded as well.
Okay.
Winston Stewart, come on.
Winston Stewart. Mr. Stewart, you're charged with 3 counts. Possession with intent to deliver or manufacture cocaine, possession of cannabis, 20 grams or less, tampering or fabricating with physical evidence. I do find probable causes to all 3. Your bond is $2,500 on count 1, $100 on count 2, and $1,000 on count 3 for a total of $3,600. Good luck to you, sir.
Thank you, Judge.
Demetrius Warwick.
Your Honor, I have nothing new on this count. He could be ROR'd on this count.
Give me 1 second. Please. Well, it appears that he jumped into somebody's backyard.
Yeah, I mean, Your Honor, if I wasn't here when it first came up, I don't know what was argued. I think the issue was evidence of intent to commit a crime therein. Frankly, I know, and the officer specifically wrote in there that there was a, it's at the end of the report, Your Honor. I'm sorry. I'm a little bit of a blank. Based on the entry, the type of entry, that there could be a presumption of intent to commit a crime therein. Stealthily entrance.
I will say that it's certainly not the strongest, but I think there is probable cause for a burglary unarmed. I'll leave the bond at $1,000.
Judge?
Yes.
I don't know if my colleague already addressed it. There was no additional information brought in by the state attorney's office. At this time, I would ask you to ROR on count 2. I believe there is case law on point in which if another judge has determined there's no probable cause and allotted the state 48 hours to perfect or any sort of time to perfect and no additional information is presented, then he's entitled to an ROR. At this time, I'm sorry, I don't want to interrupt anyone.
No. I thought you were done. Go ahead.
No, I'm done. That's my argument.
If you wish, Your Honor, you can find probable cause for trespass and set to keep the bond at 1,000.
Right.
I mean, Judge, legally, yes, that you could do, but $1,000 bond for a trespass, Judge, I'd ask you.
He's currently got a $5,000 bond for robbery by sudden snatching.
Yes, that was
that's true.
And $1,000 on the grand theft. I will find probable causes to the trespass.
Like I said, go with the paperwork. Like I said, there's this for me.
And I'll set bond in the amount of $100.
Eric, you want to record? They want you there.
Why do they want me there?
Because they said you emailing them, telling them about their stuff.
He said he can't do anything for the printer, so what does he need me there for?
Thank you, Judge.
I didn't email about a printer stuff. All I did was asking about a printer.
Oh, well, he wants you to be there at the courtroom, after court. Rich and
I've got a few things I have to do, so
You have anything else?
I can't go right now. I've got to look up something someone already else asked me. Are you going now?
Yeah, I'm going.
Yes.
All right, I'll catch up with you.
But do we have any other?
To see what's going on, because you got word that we're moving this weekend, but we're not moving this weekend.
Yes, you may.
But then why do we need to go there if we're not moving this weekend?
Thank you, Your Honor.
Let me